Hi, everyone, and thanks for joining today's session. My name is Elizabeth Reese. I'm an attorney working with the law firm of Hunt and Andrews Kurth, where I represent companies facing product liability litigation. A significant portion of my practice also involves counseling companies on product regulatory issues, compliance, best practices, and everything that companies who make products face. And today I'll be discussing product liability and regulatory compliance, two things that really everybody in the supply chain should always be thinking about, whether you're a raw materials supplier, a manufacturer, a distributor, a retailer. Almost anyone in the supply chain can be held liable if something goes wrong with a product and injures somebody, or if a product fails to meet a government standard. Lawsuits and government fines can get expensive very quickly, and not to mention the negative publicity, loss of customer goodwill, and all of those other negative things that come along with a product failure. So today's focus will be on the issues that I view to be the greatest threat to the industry right now, both from a litigation perspective and a regulatory perspective. And most importantly, what everyone always wants to talk about is the steps that you can and should be taking to avoid liability in the first place, and also set your company up for success in court or with the government in the event something does go wrong. So we'll start with an overview of product liability litigation and the current trends that we're seeing, and then we'll talk about how we can avoid that litigation and set the company up for success. From there, we'll move outside the courtroom to the regulatory world, which is in fact increasingly overlapping with litigation, especially when it comes to things like voluntary industry standards. We'll dig in on some of the key regulatory issues that your companies probably deal with regularly, the agencies like the CPSC, the EPA, and some of the recent issues that we've seen with those agencies in particular. And then finally, to tie it all together, we'll talk about best practices, mitigation strategies, and that is, how can we take a hard, self-critical look at our compliance programs, or build one if one doesn't exist. Not all companies have one, so that we don't find ourselves on the wrong end of a lawsuit or a government fine in the future. Product liability suits are brought every day in every state, but some states or specific areas of states are known for being more plaintiff friendly than others. And that just means that more often than not, you're going to see more plaintiff verdicts in those jurisdictions than verdicts in favor of the company. There's a number of reasons why that is. Some states have lower evidentiary standards. They allow, a lower standard of expert testimony. A lot of factors go into what makes a forum, plaintiff friendly. But the bottom line is that in some of those jurisdictions, and the ones that come to mind are California, New York, probably doesn't surprise anybody. But even certain parts of Texas, certain parts of Illinois, in some of those jurisdictions, if the injured person is a child, a young adult, or the injury is particularly serious, we're talking, a paraplegic case or even a death, we can see multi-million-dollar verdicts, sometimes in the tens or hundreds of millions. And part of what's fueling those verdicts is a really well-funded and coordinated plaintiff's bar. And by that, we mean that plaintiffs' attorneys are sharing information about their strategy regularly, even sharing critical documents they receive from companies in one lawsuit with plaintiffs' lawyers in a totally different lawsuit. It gives them a leg up in their suits. They've got, clearing houses, basically, where if they want to know what documents does company XYZ have, someone else has brought a lawsuit against that company and has those documents. And oftentimes are able to get those documents before they even sue you. So you don't always know what it is they know, and sometimes they know it before you know it. And kind of combining and building that alliance are the consumer advocacy groups that have really come out of the woodwork in the last 10 or 15 years, playing an increasing role in directing these trends. Especially in the last 5 or so years, I would say, we've seen consumer advocacy groups self-commission studies about products that they deem unsafe. As you might imagine, these studies are sometimes less scientific. They do grab the public's interest, though. They can cause PR nightmares for companies. And consumer groups are even suing companies themselves. They're suing government agencies like the EPA to get the results that they want. And they're also lobbying state and federal legislators aggressively to pass the laws that they believe are going to protect consumer safety, but certainly add a great deal of burden for companies, not only in the compliance, but simply keeping up with them. Things are changing so quickly. If you're a company selling in all 50 states, you've got 50 different states' laws to keep up with. So that is something that is definitely causing headaches for companies and causing compliance issues. And most of you have probably heard about class actions before. Until recently, they were actually fairly rare in product liability litigation. And they still are in the sense of traditional product liability. For a number of boring legal reasons, it's hard to build a class action over injuries to a person. But we're seeing plaintiffs start to be more creative about the theories, about the products that they're suing over. And to give you an example, we've seen plaintiffs bring class action suits claiming that the class members, the customers, wouldn't have paid as much for a product if they had known it was defective, or if they had known it contained a certain ingredient. Maybe that the product was falsely labeled, similar theories. And that may not sound like a big deal. Hey, just a couple of dollars, you would have paid less if you had known that ingredient XYZ was in there. But when you've got thousands or even millions sometimes of customers who claim that, maybe they were overcharged by just $5. Well, when you take that $5 and you multiply it by thousands or millions, that verdict can add up very quickly. So you can see how that can become a problem. And as they're becoming more creative, we're seeing those verdicts and those claims in courts across the country. Now, in terms of what products plaintiffs are suing over, for a long time, asbestos, tobacco, diet drugs, those were the high dollar claims. Plaintiffs' lawyers could bring a claim over one of those products and feel pretty sure they could at least get some money out of the claim. And now those are kind of falling by the wayside. Plaintiffs' lawyers are looking for the next asbestos. They've certainly zeroed in on chemicals. Asbestos is still lucrative. I don't mean to suggest that it's not, because it certainly is. It is its own industry. But going forward, we expect other chemicals and substances like talc, lead, formaldehyde, PFAS, phthalates, glyphosate, flame retardants, those types of chemicals to be in the crosshairs. I think medical devices and pharmaceuticals will always be a hot topic. But in terms of your more traditional consumer products, setting aside the chemicals, but products that may seriously injure children, they have been, they will be targets. Some of the more vulnerable items that have been dominating news headlines recently, inclined sleepers for infants, furniture tip over, vaping products. We've seen the CPSC and the FDA intervene on some of those issues, which increases the risk profile for these products, because the more publicity you have about them, if someone, God forbid, does get injured by one of these products, they will know that there's a lawyer out there willing to take the claim. And on that note, I'm sure everyone has seen commercials on TV advertising lawyers for certain claims, especially mesothelioma. I think everyone's seen at least one of those. But we do expect to see those start to pick up. They've been very successful for the mesothelioma and those types of claims. So they translate well to chemical and pharmaceutical litigation. So we do expect to see that continue and in fact expand. And now, something my clients always ask me is, how can we predict what product or chemical is going to be the focus of future litigation? And my answer is that typically plaintiffs are tracking legislation and regulation just like we are. They are trying to file cases ahead of, for example, an EPA announcement that it has determined a chemical is hazardous. And because litigation takes so long, what they're hoping, they're banking on that announcement happening after they file the case, but before a verdict. And then they're able to position themselves, advertise themselves as, hey, I brought the first case and was successful. They can position themselves as leaders in that particular type of litigation. Doesn't always work out for them. Sometimes they file, EPA or whoever says, nope, we've deemed this chemical to be safe. and they walk away and they look for the next thing. But we're tracking that issue in particular very closely. As we'll talk about a little bit later, EPA is pushing forward on some new chemical analyses and risk evaluations that we sort of are seeing those chemicals as possible targets in the coming years. And no matter what chemical or product is on the table, we're often seeing well-known brands getting hit with lawsuits first. It's not really a surprise. They have the deepest pockets. They have the public's attention. It might be on the front page of CNN. But many of you have probably seen news reports about something like glyphosate. It's an herbicide, for those of you who don't know, and the possibility that it could be found in popular cereal products. Some of the big names have been, hit and identified. That was part of the consumer group published studies that we talked about a few minutes ago. The same is true of talc and Johnson & Johnson. It's hard not to have seen that news. It's being covered by major news outlets. They faced, in one case, billion-dollar verdicts over its baby powder. So, we're seeing kind of those name brands get hit first. And then if those are successful, then we start seeing the other companies in the supply chain, generic label type things, then they get brought into the mix. So the question is, how do we avoid litigation altogether? This is never the answer my clients want to hear, but it's almost impossible. But there are things you can do to decrease the likelihood that you'll be involved in litigation, or at least really high dollar litigation. And as we were just talking about, it starts with anticipating what claims will be brought. For example, the earlier that a chemical may be on EPA's list for regulation, the easier it is to decide whether to phase the chemical out or prepare for complying with those regulations. Or maybe you look at the chemical, you review the science, you feel pretty confident that EPA is going to come out and say, hey, no problem. But the earlier that you know those things, the better prepared you are to handle whatever it is you're going to have to do for your business. The next thing is probably obvious, but every company needs strong upfront quality control procedures. I know that's often easier said than done, especially if you are working with multiple suppliers, or your processes are especially complex, but you would be surprised at how many companies never formally talk about quality control at all. Complacency is asking for trouble. Oftentimes it's, well, we've been doing it this way for this long because it's the way it's always been done. That is not always the best approach, as I'm sure many of you know. Constant improvement is really what we're looking for. Constant review, really self-critical analysis. And that really goes hand in hand with a robust compliance program and procedures and ways to identify and track product problems. We'll talk a little bit later about what that actually looks like in practice. But if your company doesn't have a dedicated compliance team, it can be really hard to know who's responsible for what. So I always recommend that even if you don't create a dedicated team, you at least have defined responsibilities spread out across your department, across the company, whoever it may be. And whether you have a dedicated compliance team or not, compliance really should be everyone's responsibility. And the more that you can do to reinforce that in your company, the better off you will be. Now, the next piece is a little trickier, and that may be an understatement. A lot of my clients want to warn about everything that could possibly go wrong with a product. Like all of you, everyone wants to do the right thing. Everyone wants to put a safe product out there. No one is intentionally putting a product on the market that they think is dangerous, but accidents happen. And even with common appliances, you think, a blender, for example, in a home, something can go wrong with that if it's not used properly. But that tendency, it leads companies sometimes to overwarn and over-instruct, especially in instruction operating manuals, on labels on products. You might be surprised to learn that a lot of courts will find a warning inadequate if it's buried among other warnings, if it doesn't have the right, quote, signal language. There is a difference between a warning, a caution, and a danger that is set forth in a voluntary industry standard. But a host of other reasons why that warning might be found inadequate. Communicating warnings to customers, it's not an easy task. It requires a very, very close understanding of your product. its risks, its uses, how your customers are going to use it as your audience. Are they children? Are they adults? Are they people are they, companies, should they know how to use this product? All of those factors affect how you warn, when, and what warnings you give. And the law also plays a big part in it. It's something that I think is often overlooked. We are seeing more companies coming to us now and saying, hey, we need to get our arms around our instruction manuals. For a long time, people just didn't realize that was something that from a legal perspective really needed to be looked at closely. And finally, there are a few things you can do up front to shift the risk of litigation to other people. The first thing is, depending on where you are in the supply chain, you can negotiate risk shifting provisions in supplier agreements. We represent a lot of retailers or distributors. And generally, those downstream companies can ask the upstream company to assume the risk of any litigation, to indemnify them for the cost of any litigation. Sometimes it might be the other way around. That's a little bit rarer, but it's not impossible. Kind of depends on the relationship between the companies and what the product is. Product liability insurance is also available. Recall insurance is available. That's something that we always recommend our clients look into. Sometimes it doesn't make sense, but it is something that is at least worth exploring depending on your business and where you fall in the supply chain. Turning now to the regulatory landscape, we'll leave litigation behind for now, although we will certainly come back to it. These are just a few of the regulators with a hand in your industries. The Consumer Product Safety Commission, the Environmental Protection Agency, those are the big ones, of course. The FTC regulates marketing and advertising, and I like to throw the USDA in too, because a lot of people are surprised. The USDA might be involved in things that aren't related to food, but they actually do have a hand in products as well. For example, you might need to file a certification if you import wood or any product containing wood. And of course, there are state agencies regulating products too. Most everybody has heard of California and Prop 65, certainly causes a lot of compliance challenges. But a lot of other states have similar regulations. California is not alone. There are state level EPAs, there are similar agencies that need to be dealt with if you operate or sell any products in the particular state. And I'll tell you that this day and age with online commerce, you can reach almost any state you want. And if you're selling to customers in those states, you are subject to regulations in those states. And that can be really, really hard to keep track of. And in some cases, quite frankly, almost impossible. But it does certainly raise the risk the more states that you're doing business in, because there's more things that you have to comply with. And now the Consumer Product Safety Commission issues regulations under the authority of two laws. And I just want to give a brief overview for those of you who may not be really familiar with the agency. The first of the laws has been around since 1972. It actually established the agency, it gives it broad authority, but over time, Congress decided that the CPSC needed a clearer mandate. And so in 2008, Congress passed an amended law that focused specifically on setting regulations for children's products and record-keeping obligations, and really kind of shored up the authority that the CPSC already had. Again, the CPSC has broad jurisdiction over consumer products, and we can talk probably for a full hour on what a consumer product is. There is a definition. It is not a satisfying one. The answer, it's the classic lawyer answer, is it depends. Some things you can look at and say that's definitely a consumer product. Some things you can say it's definitely not a consumer product. Some products, depending on where it's used, may or may not be a consumer product. But the point being that the reach of this agency is broad. It issues regulations, it manages recalls of defective or non-compliant products. It can even ban products altogether. Two examples here, asbestos and joint compound was banned in the late 70s. Lawn darts, some of you may remember the lawn dart game, which, in retrospect, looking back at it, it's a very dangerous game, and the CPSC decided that the United States will ban it altogether. All-out bans are fairly rare. Usually they're regulating a product, they're not taking it totally out of commerce. those two certainly being exceptions. The CPSC can even bring lawsuits against companies who refuse to recall products. They issue penalties for noncompliance and for violations. And the important thing to remember here is that the CPSC has jurisdiction over everyone: manufacturers, distributors, retailers, and everyone can be held equally liable for a violation or a defect. Again, it'll depend on kind of the specific issue. If you're just a supplier of a component and that component has nothing to do with the particular product defect, that's a separate issue. But oftentimes retailers are surprised that they might get a CPSC penalty, saying, well, hey, we just sold it, we didn't make it. Well, the CPSC will penalize anyone that they think should be held liable. And oftentimes it's, if the manufacturer, for example, is overseas, the only person the CPSC can punish is the retailer. So it's just something to keep your eye on, and understand that even if it may not apply to you, everyone further down in your supply chain is concerned about it. And so it's helpful to understand what they're facing so that you can be responsive to their needs, get them the products, and move forward with a productive business relationship. So in terms of obligations under these two laws the CPSC administers, companies' key obligations are to report unsafe products, remove them from the market by recalling them, and to cooperate with any investigations. If you're the manufacturer of a product made in the United States or the importer of a product made overseas, you are responsible for ensuring the final product is compliant with all CPSC regulations. For some products, you are required to issue a document certifying compliance with regulations. That's not true of all products, but we'll talk about those in a few minutes. A lot of companies use foreign manufacturers, which can make this compliance part hard. The CPSC generally does require in those circumstances that you use what's called due care, which again, kind of an unsatisfying definition, but basically don't bury your head in the sand in terms of ensuring that you're getting accurate information from your foreign manufacturers about what's in the product, if it complies, all those sorts of things. You will be ultimately responsible to the CPSC if it's wrong. The penalty might just be a little bit less if you did everything you reasonably could to ensure that you're getting accurate information. So as I just mentioned, manufacturers of US products and importers of foreign products have to issue a written certificate that certain products comply with all CPSC regulations. The list of those products is too long for our purposes today, but suffice it to say that many consumer products require them. A lot of furniture, refrigerators, things that you might be surprised require these regulations or these certifications. If the product's for children, it has to be tested and certified by a CPSC recognized lab. Any lab can test a product intended for the general public. I always recommend having any products that need to be tested, have those tested by a CPSC recognized lab as well, just as a best practice. You generally can feel a little bit more confident that if the CPSC has recognized these labs, that their procedures are done the right way, and that you're getting reliable information. These certificates have to accompany imports and be available with the shipment. And that means either physically, or you can include on the shipment paperwork a URL the customs agent could access if they wanted to review that particular shipment. Missing certificates can delay shipments. Technically, if you're missing one when it arrives at the border, it is a violation of CPSC regulations. It could be subject to a penalty. Right now, that's not a focus at the border or with the CPSC, although I will say that very recently, the CPSC has started discussing a way to file those certificates through an online system ahead of them arriving here. And once that happens, if it does happen, if that's implemented, it will be much easier for the CPSC and customs to catch products that are not accompanied by those certificates. The certificates do have to be provided by either the manufacturer or the importer to the next in line distributor or the retailer. There's no obligation to pass them on beyond that, including providing them to customers. You don't have to do that. You do have to retain them for a certain period of time. We'll talk about document retention a little bit later. And the other thing I'll mention is that this is a fairly new requirement, dating back to 2008. So a lot of companies, you'd be surprised about how many companies don't know they need to do this. Again, not all products require certificates. The CPSC has a list on their website of the products that do. I would recommend reviewing it and making sure that this, if you're a manufacturer or an importer, that you are issuing those certificates if you are not already. So in terms of obligations to report things to the CPSC, everyone sees news reports about recalls of certain products, but not a lot of people think about what goes into reporting a product issue to the CPSC. And this is where we see a lot of companies trip up. CPSC regulations require really quick turnaround for companies to report issues. They have to report if they discover a product fails to comply with any safety standard or regulation. If there's a defect posing what's called a substantial product hazard. Again, that's one of those things that can be up to interpretation. Certainly you must report if you discover the product has caused serious injury or death. Most of these issues are resolved with the CPSC confidentially. The CPSC doesn't necessarily always make a finding of substantial product hazard, which can be helpful in litigation, but you only have 24 hours to report after you receive knowledge of any of those things. That is a really quick turnaround. And if you don't have a process in place in your company, we often see companies coming to us saying, well, our sales guy found out a week ago and it only made its way up to us, in the last day or two. There needs to be a very defined process, and we'll talk again a little bit later about what that process actually looks like. If you do wait longer than 24 hours, you may face an even greater penalty, but the advice is always report, 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 even if you're outside that 24 hours, just because the more likely it is that the CPSC is going to raise an eyebrow at how long you waited. And there's also another lesser known reporting obligation regarding lawsuits. And this is an example of where litigation and regulation intersect. CPSC regulations require companies to report any product that has been the subject of 3 lawsuits over death or grievous bodily injury in a given 2-year period that resulted in either a plaintiff verdict or a settlement. And that's a little bit of legal jargon, but to complicate matters a little bit further, it's not just a standard 2-year look back. It's a statutorily set 2-year period that actually runs from January of odd years through December of even years. So even if you've had 2 such lawsuits since January 2019, and you've got another one settle on December 31, 2019, you have to report it because that's 3 within the 2-year period. But if that 3rd case settles on January 1, the next day, 2021, you don't have to report it because it's a new period. It can be really difficult to track, but the penalties for a failure to report can be steep. So we do, again, we'll talk about ways to track that a little bit later. And I don't want to spend too much time on recalls because they really could be an hour-long presentation in and of themselves. I do want to give just a very brief overview for those of you who are not familiar with the process at all, just so you know what it is you're trying to avoid. Recalls can either be voluntary or mandatory. When the company refuses to recall a product, the CPSC will make it mandatory. You don't really ever want to find yourself in a situation where there's a mandatory recall because the penalty associated with that is steep. Some companies, they dig their heels in and say, there's nothing wrong with our product, we're not recalling it. But oftentimes if the CPSC is pressuring you quite a bit, there might be something wrong with it. And that's not to say there's never a situation where you shouldn't stand at the CPSC, but generally it doesn't reach that point. And the CPSC has a number of procedures that can make it, I don't want to say easy because a recall is never an easy process, but they do have something called a fast track recall. if your company is prepared to execute a full recall within 20 days of making a report, you can take advantage of this fast track. And it can be a great option because the CPSC won't make a formal finding of a substantial product hazard, even if there might be one. And that can be really helpful in litigation because you're not working against a presumption if someone sues you over the product later. But again, you got to be ready to execute that full recall within 20 days, which depending on the scope and the product can be very intimidating, but it's why I always recommend that companies have a recall contingency plan in place. Or in a recall, of course, it must also have a remedy. That's a key part of this. The remedy can be a repair of the product. It can be a replacement, a full replacement, or a component part replacement, whatever fixes the defect, or it can be a refund. It can be some combination of all of those remedies as well. And we'll switch gears a little bit here to a different agency, the Environmental Protection Agency, the EPA. Most people associate the EPA with outdoors, but it also has a significant amount of control over consumer products, especially when it comes to chemicals. It does overlap a bit with the CPSC in a number of areas, but generally speaking, EPA regulates chemicals and products containing chemicals, and it does so under the Toxic Substances Control Act, or TSCA, you'll hear me call it. And under TSCA, companies have labeling obligations, they've got record-keeping obligations, reporting obligations. Again, TSCA, probably not even an hour presentation, we're talking several hours presentation. We're just gonna focus on one small part of TSCA today. But just like the CPSC, the EPA considers an importer of a foreign product to be the manufacturer, so there are often additional responsibilities for importers they might not otherwise think about. It's just something to keep in mind if you are in a position where you're an importer of a chemical or any product containing a chemical. And this is a little bit of a case study. I know not all of you will have dealt with this, but some of you might have over the last few years. The formaldehyde final rule for composite wood products, which is a new rule from EPA. Even if you don't have any composite wood in your products, it's a good example, this rule in particular, at how litigation and regulations intersect and can cause compliance problems. The formaldehyde rule sets emissions limits, labeling requirements, record-keeping requirements for composite wood and products containing composite wood. The rule was supposed to take effect in December of 2017, but in September of that year, EPA announced a year-long delay, basically just to give companies more time to comply. Consumer groups challenged that delay in federal court. The case was settled in late March 2018. And as part of that settlement, EPA agreed to start enforcing the rule as of June 1, 2018. So again, we're talking late March. They're announcing, hey, just a couple of weeks, June 1, we're going to enforce this rule. And so that meant that companies who thought they still had over 9 months until December of 2018 before that rule actually took effect, they were caught off guard. Some of the affected product was already on the water, was already shipped from overseas, meaning that it would arrive non-compliant at the border, and EPA made clear that if it arrives, it's non-compliant, it's subject to penalty. Any of you who, like me, lived through what I now call the summer of the formaldehyde final rule, remember what a compliance nightmare it was. And the formaldehyde rule is also a great example of how expensive non-compliance can be. In August of 2019, EPA issued a $544,000 penalty for 17 products that a company self-reported were non-compliant. And what's really interesting about this penalty, and important to note, there was no evidence or discussion about whether these products complied with the emissions limits or not. In fact, they probably did. Had they been tested and everything, they probably were below the emissions level. But the penalty was for the lack of labeling as compliant. And $500,000 for 17 unlabeled products is pretty eye-opening, especially when you consider that this company self-reported the issue to EPA. And what that means is that EPA is taking enforcement under TSCA really seriously. And over the next few years, that could get very complicated for companies. And the reason why is that EPA was given new powers by Congress in 2016 to review and regulate chemicals by conducting comprehensive risk evaluations of chemicals. those risk evaluations will include EPA's conclusion about whether a chemical poses a substantial hazard to human health or to the environment. Now, EPA was supposed to finalize its first 10 risk evaluations in June 2020, and we've listed here some of those chemicals, those 10 chemicals. Those risk evaluations, most of them have been delayed. It is worth noting, it was clear long before COVID that EPA was not going to meet the deadline. They signaled that they were not going to meet the deadline, but certainly COVID hasn't helped speed anything up at the agency, and they're probably even more behind than they already were. So it is really hard to tell when those final few risk evaluations, they have released a few, they have not released all 10. It's hard to tell when those in fact will be released. But of the ones that have been released, EPA has found for some of them that they pose unreasonable risks to human health or to the environment. And TSCA requires EPA to issue regulations for any chemical it does find hazardous. So what that means is that for those few chemicals that EPA has found pose a substantial hazard, EPA's now got to go through the regulation process. We expect them to release draft regulations within about a year or so of their final risk evaluation for any given chemical. So we'll probably, for the few that have already been released, looking at next summer or so for draft regulations. And then after that, there's a process where there's public comment and all of that. So probably not looking at final regulations for another year and a half, 2 years, maybe longer. But once that hazard tag has been applied to a chemical, that's when you start seeing some risk on the litigation side, to the extent there was not already risk, and a lot of these chemicals already do have risk. There's already lawsuits over them. But EPA here, they've also started risk evaluations of 20 new chemicals. That's, again, prescribed by law. TSCA requires it. That includes formaldehyde. So there's more formaldehyde action coming. It includes phthalates, flame retardants, many other chemicals that are probably in your products. And if they're not in your products, they might be in your manufacturing processes. These are all really important things to keep an eye on. It's important now to understand where these chemicals fit into your supply chain and your manufacturing processes so that you're prepared for any increased pressure on your company, whether it's from your suppliers, whether it's from your customers, whether it's from plaintiffs in court, so that you're well positioned to comply with any of these regulations that are coming out. And because, again, as we talked about a little bit earlier, these are the chemicals that plaintiffs are looking at right now, that they're going to try and get companies into court over them, and they're going to try to capitalize and gamble really on, well, you know, maybe they think that on this particular flame retardant, EPA is going to come out in a year and a half or 2 years and say, we deem this chemical as posing a substantial hazard to human health. And then plaintiffs, they've got a bag full of lawsuits ready to go. So it is a really dangerous thing, but there are things that you can certainly do now to prepare for that. And whether it's, again, phasing it out of your supply chain or simply coming up with a way, a plan for how to address it if there is an unfavorable finding. In voluntary industry standards, I mentioned at the outset, they come up all the time in both litigation and regulation. As the name suggests, and I know that many of you are familiar with what voluntary standards are. Most voluntary standards are really just that, they're voluntary. But over time, some of these standards have become so well accepted in the industry that they are effectively mandatory. And that's just, it's not mandatory by law. It's just that a lot of companies have adopted them, so that if you're not doing it, you're kind of an outlier in the industry. A good example is the clothing storage unit takeover standard. In fact, earlier this year, the CPSC even said that it would consider any product that doesn't comply with the voluntary standard to be defective and subject to recall. And it has, in fact, recalled products that did not meet that voluntary standard. In fact, it's recalled many products that do not meet that standard. Some standards have actually eventually even been incorporated into formal regulations. So oftentimes these voluntary standards are the jumping off point for regulation. So if you're already complying with them, you already have a leg up when a regulation comes out. And on the litigation side of things, non-compliance with an industry standard can be strong evidence of negligence. How powerful that evidence is may depend on the jurisdiction. How compelling it is to juries may depend on the specific standard, the type of injury, the type of product. A lot of things go into that, but you don't really want to find yourself in a courtroom explaining why there's a well-accepted industry standard for safety that you didn't follow. There are, of course, some exceptions if your product design is different, if the test isn't exactly applicable to your product. There are definitely arguments against that, but if there is an industry standard that applies clearly to your product, it is a best practice to follow it. And here at the bottom, these are just some common examples of organizations that I know many of you are familiar with that issue voluntary standards. UL, of course, has an emphasis on electrical components. ANSI accredits others who develop standards. ANSI will then approve them, a broad range of standards. ASTM, again, a broad range of product and testing standards, test method standards. CSA, that's the Canadian agency, kind of the Canadian equivalent. ISO, internationally, of course. ISO also includes representatives of various national standards organizations. And as I just mentioned, the CPSC often participates in voluntary standard development. On their website, they've got a list of working groups that they're working in, topic sets they're looking at. They're always participating in conference calls with the voluntary standards working groups. The CPSC is obviously very influential in the development of these standards. And a good rule of thumb for companies who are looking to mitigate litigation or regulatory risk is to use these voluntary standards. They are great tools. They should be the starting point for product development. And that means knowing what standards apply. Sometimes that means bringing in an expert, a consulting expert, to tell you what standards apply. What standards don't apply sometimes is just as important. But having those answers and that understanding and checking off those boxes so that you understand what it is you're doing and why. Sometimes it means asking hard questions from suppliers. Companies should they should retain evidence from their suppliers that they are complying with these standards. Write it into your policies, write it into your contracts. There are all sorts of things that you can do to make sure that you are getting the compliance level that you're looking for. So to sort of tie all of this together, the question really is, what is it that companies can do to give themselves the best shot at not only putting safe products out on the market, but also managing on the back end any litigation or regulatory issues that pop up? There are a number of things that are hallmarks of an effective compliance program. These are my key points. It's got to be a written program. You've got to have written policies. That is the jumping off point for all of this. Written product safety, quality policies and standards, regular product testing. You've got to have vendor and supplier policies, again, written. You've got to communicate them and you have to enforce them. There's a temptation, if you've got a great relationship with a supplier, to kind of let things slide. But once you let things slide, they keep sliding. So it is important to audit, to enforce these policies and make it clear that your company is looking for compliance. Part of that is a clear allocation internally of responsibilities. If you don't have a central compliance department that is doing all of these things, you need to have people whose job responsibilities are clearly defined to capture all of these parts of a program that you would have if it were a central department. And again, we alluded to a little bit earlier, you want to have a defined process for handling and resolving complaints or reports of issues. Regular training for all personnel. You want to make sure that that includes legal, quality, vendor relations, customer service representatives, store salespeople, everybody who's involved in that, who has a role in getting that product to the customer, is important to include in this program. As I mentioned, you want to have periodic audits. You want to identify gaps in areas. You always want to be looking for ways to improve. If something goes wrong, you fix it. You don't just say, well, we'll know not to do it again. You want to sort of have I've used the phrase a few times, a self-critical analysis. We want to make sure that we learn from that experience. And again, this program is going to be evolving just as quickly as these new laws and regulations are coming out. Those lessons learned as personnel changes, you want to have some continuity. So it's really important to make this compliance really part of your culture. Kind of what are the most important things to do to get started with this? Designate somebody who's responsible for product safety. This person is going to be the central coordinator for quality control records, for test results, for complaints and claims, lawsuits, workers' comp claims, recalls. It could be more than one person. I know that sounds like a lot, but whoever it is, you know, or whoever those persons are, they are going to be where all of this starts. And you also want to define the complaints and the claims process. Obviously, the cornerstone of this process really is the identification and the documentation of specific complaints. You want to have a standardized intake procedure so that whoever receives a complaint collects the information that the company is going to need. In this modern age, companies also need a way to coordinate and develop a logic flow to identify repeated issues or multiple reports about a specific product or a specific issue. These days, you've got product incidents coming in by phone, by social media, you know, someone tweeting at your company through your website, if you're selling through a third-party seller on their website, any number of avenues where you could be hearing about a claim, even a lawsuit. There is technology available that can scan all of these sources for keywords, for trigger words that can flag problems that might otherwise slip through the cracks. You know, you might have 2 reports on your website of an issue, your customer service report, or your customer service representative gets 1 report, but the customer service rep thinks, oh, that's an isolated issue that only happened once, when in fact we know it happened 2 other times, but that customer service rep isn't looking at the website. So all of those things need to be taken into account, given the complexity of how, and the reality really of how businesses are operating today and communicating with the customers. And you know, obviously underpinning all of this is records maintenance. It's critical. Document retention policies should be written. They should align with all legal and regulatory requirements. I mentioned a little bit earlier that the CPSC certificates that you have to issue for some products, you've got to keep those for a certain number of years. TSCA has got its own record keeping requirements. There are a lot of moving pieces here depending on what it is you have to comply with. And that policy should be regularly audited. It's one thing to have a written policy. It's one thing to say we're keeping these documents for this long. It's another thing to make sure that process is working. Things slip through the cracks. And again, that just goes back to the lessons learned, constant improvement. And just to leave you all, I know we're getting short on time here, leave you all with a few thoughts of where we really see litigation and regulation heading. Of course, COVID has thrown a wrench in all of this, and I think we all know now that predicting a day, a week, a month in advance, it's no small feat, but generally, these are the issues that I suggest keeping a close eye on over the next year or so. And number one being the Share Information Act. This was a law introduced in Congress in January of 2020. It would allow the CPSC to share confidential business information without permission from companies. Right now, there are a lot of safeguards in these reporting mechanisms that protect companies and encourage companies to share information with the CPSC. This would roll that back a little bit, not in all circumstances, but in a lot of circumstances. On the industry side, on the company side, you know, with the hat that I'm wearing, this is something that might discourage companies from reporting, but certainly you're still legally required to report. So you might find yourself in a situation where this confidential information is shared when you didn't ever intend it to get out. So just something to keep an eye on, another kind of the piece of the puzzle moving forward. As we talked extensively about TSCA and the chemical review, there's going to be increased publicity. There's going to be draft risk evaluations. We've got flame retardants on the deck, phthalates, again, more formaldehyde. These are really common chemicals in really common products. We do expect consumer groups to challenge EPA. Again, this is something that could be a whole separate presentation on how they've approached the risk evaluations and the conclusions that they're making. If a consumer group thinks that EPA should find a chemical hazardous and it doesn't, We expect them to challenge that in court. All those sorts of things, going back to the formaldehyde rule, can throw litigation, or throw regulation really into a gray area where you don't know what's going to be effective and when. And again, more formaldehyde, Canadians are planning to issue their own rule. It is expected this year, although we are getting towards the end here. And with COVID, I don't know if that's still going to be the case. It will likely be very close to what the US rule is. But for those of you who are dealing with the formaldehyde final rule in the US, and if you're also doing business in Canada, you're going to have to deal with the Canadian regulations too. I expect there to be slightly different labeling, so we'll have to work through those issues again. And then finally, increased PFAS activity. PFAS they're known as forever chemicals in the environment. There's been a lot of regulatory activity in terms of stain treatment, carpet bans, use of PFAS in those materials. As PFAS sort of takes center stage, I do expect that we're going to see some increased litigation. We're already seeing a lot of it, but especially as regulation increases, litigation will also increase exponentially. And that's it. I know that we're going to take some time for questions now, but thanks very much for joining.